Good evening and welcome to Plain Talk. As you would have seen in the introduction, this is the final program and therefore the final curtain, which is being held in November because we had a problem in October and the final program, in fact, was not aired until tonight. I have my guest, Mr. Carl Greenidge, who has been a great friend of Plain Talk, and he has joined me this evening, and I guess I want to talk on a number of general issues. I suspect his focus would preferably have been on the Anti-Money Laundering and Countering the Finance of Terrorism Act or Amendment Bill. But let's see how it goes. Mr. Greenidge, welcome to Plain Talk.
Chris, thank you very much for that warm welcome. I also wish to say that I'm delighted as usual to be able to join you tonight, you and your audience. I am sad, however, that in joining you, this has to be the final Plain Talk program. I hope that that final doesn't prove to be that final, and that we can have an opportunity in the future to exchange ideas in public, if not necessarily under this name, by another name. But I look forward to that.
Thank you. You've just had a recess, what people like to use this word statutory in Ghana. We've had a statutory recess under the standing orders. There are a number of issues that were outstanding when Parliament went into recess. The 4 local government bills were still somewhere between the President and the Attorney General and the Clerk of the National Assembly. We've been talking about Procurement Commission. The Select Committee on the money laundering. All these things were in train. I guess you come back and they face you just as they were then. Should we have dealt more expeditiously with those matters? Should we have said, look, let us suspend this recess. Let us address these national issues.
Chris, let me be brutally candid with you. The reason why the Parliament hasn't completed a number of issues, including the ones that you have just raised, has actually nothing to do with whether a recess in August, September, October is appropriate. It has to do with what the government would like done. We were due to reconvene in October. I think October the 11th was the date from which Parliament could have started its sessions. There's been no parliamentary session. And as of today, I have not seen the order paper for the next session, which I was told recently should be on Thursday. So
that's Thursday the 7th.
Thursday the 7th. So practically a month has been wasted. It's been idle. And when you go back to the beginning of the session, you will recall that we met, I think, at the end of December 2011 or early in January 2011. Weeks passed. The government is not interested in having these things move because many of them are issues that the opposition, for which the opposition would amend the legislation in a manner that the PPP does not want. So as far as they're concerned, you only hold sessions when they have bills, when an urgency faces them in respect of the bills. So even though we are going to meet again on the 7th, the same thing will continue.
But is it your system? And I think our viewers are always a little bit confused about the procedures, elaborate and sometimes arcane procedures of the National Assembly. Were you required to table your amendments in advance of the 7th?
You're speaking now specifically
Today.
to anti-money laundering?
Yes.
No, you're not required to table any amendments. This is a red herring. The bill, the amendment bill which is before us, has been the subject of some discussion by the Select Committee. The Select Committee isn't bound by the meeting of Parliament. as such. So let's separate the two things. The point I'm making...
So the select committee could have continued to work even during the recess?
The select committee could have worked since October, even though the plenaries will not have commenced. The select committee could have been meeting.
Could they have worked during the recess, or all the activities of the National Assembly go?
The activities normally will go, but of course you can get special dispensation if that is required. But people commit themselves. I think one has to be remembered, and I don't want to spend too long on this, is that parliamentarians are not full-time parliamentarians. The only parliamentarians that are full-time, in a sense, are the government parliamentarians. So other people have to earn a living.
And that applies to some members of the government side as well. Not all of them are full-time.
I would not like to even comment on that. I would not even like to comment on that.
Because some of them are independent professionals, aren't they?
Let's leave that, Chris. I hear you. I hear you.
Now,
but the point is that parliamentarians can be provided with assistance of various types. And what the opposition MPs don't have, in many instances, the government has.
We'll get to the details.
But the point is that the select committee could have met.
Been doing some work, at least since the 7th.
Yes, and the select committee had also decided, if I might just finish it off, Chris, they had decided to do some things. They had been looking at recommendations from people who have submitted comments, including yourself. I gather that it is the view among some people, including some in the diplomatic community, that the civil society, they have no particular skills, so why bother to waste the committee's time by requiring that they
Who said that? The members of the diplomatic community?
I've heard that view voiced.
Well, you know...
But Chris, let me finish, please, because, that
I find
is
that
so
one
absurd.
very offensive.
Exactly.
I find it very offensive.
So let's not really bother to follow that up. I just wanted known that certain people who are clamoring for the instant signing of these bills are of the view that you should take no notice of the submissions. Amongst the submissions that have not been considered by the committee, including because they were late, that's one of the reasons, and that's a fact. I mean, we are a society prone to that sort of thing. The government itself has held on to a bill for 2 years before enacting it in 2009. Submissions were late, but they are with us, and they have not been fully considered. The process, which you asked, did we fail to submit amendments? The answer is no, we didn't fail to submit amendments. The process as regards the members is as follows. One goes through the different sections. That's what we've been doing. And as you arrive at a section, if someone has an observation or they would like an amendment, it is then put to the meeting at that time. You have draftsmen who are with the team, and when the member voices a proposal, the draftsman can be asked to capture it if it isn't presented in written form. The fact is that we have not yet got to the elements in which we, as the APNU, wanted changes reflected in the main changes reflected in the text, but there are a number of changes that have actually been incorporated in the draft, which came from members who submitted no drafts. The definitions, the treatment of ID cards, whether the local ID cards and driving licenses are, for example, acceptable, they are not the subject of a written proposal. So this is just a bogus argument that the APNU has failed to submit its proposals and now is wasting time by calling for these changes.
I know you're tempted to dismiss this issue of the diplomatic community. I mean, whether that was said, whether that's hearsay or whatever. What we do know is that the diplomatic community has been inserting itself in this process.
Yes.
When there are many people who find that, when did we become independent? 1966. And here, others telling us, and in fact, even Dr. Roger Luncheon saying that the legislation isn't driven by the parliamentarians, but by somebody outside.
No, well, Roger is right in that sense. He must know.
That he didn't care about the elections? About the amendments?
No, precisely. He is speaking on behalf of the government. You know, that government passed legislation in 2000, did nothing about it, absolutely nothing. Indeed,
That's the money laundering,
that's
anti-money
correct.
laundering
That's
act,
correct.
yes.
Between 2000 and 2013, in fact, the government has intervened. The political apparatus has intervened on several occasions to give back to persons whose property have been seized by the army or by the police or by authorities, to give back to them their assets. So the reason why we are at a debate now is not because the government wants it, it's because the international community has wanted it. The point I'm going to make, I mean, I hear you as regards the involvement of the diplomatic community here. The thing is that it is an issue which touches upon collective responsibilities of states within the region and between ourselves and bilateral partners, United States, Canada, United Kingdom, and so forth. So I can, at the European Union, I can understand that they will want to encourage us to do things that will not lead to difficulties or to take action that will facilitate international cooperation. I have no problem with that. I think the problem comes, and the line between interference in our internal affairs and that type of action comes when the diplomatic community feels obliged to tell us, as indeed as some of the private sector, you must pass this legislation with the proposals that have come to you, irrespective of its inadequacies. And that is a problem because we are facing a constitutional crisis.
Mr. I mean, we'll get to the legislation, and there are lots of things about this legislation that are unconstitutional and that can be blocked by the court. So I don't know this headlong rush and disregard for constitutional requirements. But I want to raise some other issues, because we ordinary citizens, and I'm distinguishing ourselves from you politicians, we are concerned about no local government elections, no procurement commission, no ombudsman. Now,
executive lawlessness.
How can we, no integrity commission, how can we and why must we regard these amendments as being more important than constitutional guarantees that have been ignored for over 12 years?
Well, Chris, the diplomatic community, of course, has its own axe to grind. It has its own mandate, and one cannot disregard that fact or criticize them for that.
I'm talking about I'm talking about our politicians.
I know.
I'm talking about APNU, PPP.
Well, our politicians are subject to pressure from those quarters, and I'm saying that if you have that pressure, you have to understand that it is exerted sometimes improperly. But it is our duty. It is our duty as representatives of the people to ensure that the people's interests are paramount, whatever other interests we may have across that international line. And let me just follow up a little bit on what you say. You know, money laundering and the legislation pertaining to money laundering, as have been in existence here for over a decade. And the problem as cast by CFATF, this is the Caribbean body that looks at this matter, is, I believe, unfortunate, because the legislation has 107 clauses. That is the legislation that is in place. The substantive
legislation, yes.
They are proposing something like, I think, 28 additional changes. Okay? That's the legislation before us right now. These are changes ranging from tightening up of the definition, requiring data to back up things like transfers, information on the people carrying out the activities and so forth. Some of them are tidying elements
and they're just procedural.
And some of them are just procedural. The problem is, however, twofold. One, legislation is not being enforced. And two, we are already operating in a system of executive lawlessness. So when you add to these refinements that the bill contains, the elements pertaining to terrorism or pertaining to the financing of terrorism, you recognize that you are putting in a government's hands greater powers, which powers pose a threat to many of us ordinary citizens, as you call them, and even us, politicians, who are on the wrong side of the political divide. Without the constitutional guarantees, you are putting in the hands of an already irresponsible government the potential to do more wildly than it currently does the things that often precede elections. Say, for example, we have two officers, Monroe and, who is it, Monroe and the other officer and his wife, who were locked up just before elections.
Was that Ned?
No, it wasn't Ned. You had the case of a journalist jailed for treason, never convicted but serving 5 years in prison. All of these must be borne in mind when you are adding to the powers of the government the capacity to use a wider net. Well, and you need safeguards. Those safeguards need to be in place.
Raymond Gaskin, who was in the program a couple of weeks ago, he pointed out, for example, that the Attorney General will be assuming some of the powers of the Director of Public Prosecution, which is clearly a violation of the Constitution.
Well, you see, part of the problem here is two sets of things. Some of the legislation that is coming here is based upon a system that is alien to us. Okay? And you have in this system officers who are creatures of the president, such as the Attorney General, announcing that he is the protector of the Constitution. So you have ignorance compounded by inappropriate legislation in some instances. That poses a danger to all of us. That point you're raising is precisely what worries us. We have our protection from executive lawlessness lies in the courts. And in those courts you have no proper financial independence. You've just mentioned unpredictable decisions, constraints on and issues pertaining to the manner in which the judges are appointed, problems of the appellate tribunal, the Judicial Service Commission. All of these things relate to the effectiveness and the potential threat to civic liberties of the legislation before us. And let me just remind you, both in the United Kingdom and in the United States and in Europe, civil society has woken up years after the rest of the world is looking and saying to the US, well, how could you be doing this? You are supposed to be the bastion of democracy. Here you have a president encroaching on your rights. Years afterwards, you suddenly see in the US, people are saying, oh, you know.
Telecommunication.
All right, okay.
Edward Snowden all over again.
Electronic, yes.
But I want to raise this question to you as a politician. You say that you accept that there are this anti-money laundering and countering the financing of terrorism that's being driven partly by the region, partly by the international community.
And legitimately so, yeah.
But you've got to balance this. You've got to balance that with all the other constitutional violations that are taking place. The absence. Now, when I read, when we, ordinary citizens, read about the what the APNU is saying, or what it seems that there's not sufficient emphasis being placed on all these other constitutional violations. Is that a fair comment?
It may be a fair comment because certainly, I can't speak for the FC, but certainly the APNU has labored from the time of its inception or soon after with less than adequate PR preparations. And the type of public pronouncement sometimes lands us in trouble. So I think the presentation is perhaps what is failing, but let me say to you that when this sub-select committee started meeting, I remember being interviewed and giving a presentation to one of the newspapers, which was published on a Sunday fully. They didn't cut anything out, in which I explained my understanding of the situation as regards this legislation, and it included reference. A good part of it concerned the question of our rights and our civic rights. Of course, one newspaper presentation does not constitute a PR campaign. So that is part of the failure, and I admit that. But it is not the case that we haven't mentioned it often enough. part of the problem, if you have two political parties, the emphasis is always going to be different.
We hear about all the garbage in the city and all these things about the bridge and the Ministry of Local. But that's a failure to carry out the Constitution and to make sure we have local government elections. The last time we had local government elections was 1994.
It is
now,
a disgrace.
Is it that your group, the APNU, is it that it expects local government elections shortly and is not making that a sine qua non, a prerequisite for other areas of cooperation?
No, the APNU knows that the government has an obligation to put in place local government elections. Most of us feel...
It has had that for how many
years?
Yes. It has for
you are right. Notwithstanding what the APNU leadership has said, there are a number of persons within and outside of that leadership that believe that the government, whatever it may have said, has absolutely no intention of calling any local government elections because it knows that it will be embarrassed by the outcome of those elections. We, in the course of the discussions with the AFC and the PPP, have made it very clear that we believe that the president, just as he has a deadline to meet on behalf of the country in relation to anti-money laundering and anti-terrorism legislation, also has obligations to meet as regards other deadlines. He has legislation before him, which, as you have mentioned, he has failed to sign or to give a sensible excuse or a legitimate, properly constitutionally consistent legal explanation, and the deadline has passed. And you get all sorts of lies. I'm sorry to put it this boldly. One, concerning whether he's seen the legislation, and two, concerning the role of his creature, the Attorney General. And this is an issue that we have been fighting with for a long time. You remember you are raised with the clerk in a public exchange what the responsibilities of the clerk are. I noticed that the clerk in an outburst was complaining about the state of the parliament. Well, let me just remind the clerk of something. Whatever the status of that parliament, he has obligations which are set out in the law, and he has a responsibility to carry out those obligations, whoever harasses him.
Well, but it can't be harassment. No, that was nonsensical from the president and the cabinet secretary. It's absolute rubbish.
Well, no, I would not
to call on Mr. Greenidge, to call on a public officer to do his duty. It's not harassment.
That is the point. I agree with you absolutely. That is the point. I think it is important that they call it harassment because you're calling on him to do something which they find inconvenient, and that is why it's classed as harassment. But it is part of his duty. And if he is being asked by two different parties to do things that or at least one of which
and I believe
is inconsistent.
Isn't it clear the constitutional position as well? He's bound by the Constitution.
He has to be immune. He has to be immune to that. So that one really needs to put aside. But the point is that we recognize that there is an obligation to do a number of things, and we continue, however poorly it might have been articulated, we continue to insist that you need to have them in place if the legislation itself is to be effective. One of the problems with CFATF is that whilst it may be technically competent, it clearly is unfamiliar with the context in which this legislation has been laid in Guyana. But it can't be so unfamiliar as to not draw implications from the fact that a government in 13 years has never prosecuted anyone, and that it makes little sense to the average man in the street to say, look, you have 107 clauses, add another 15 or so, and then we are going to treat you as conforming to the requirements, when in fact you've never prosecuted anyone.
Mr. Greenidge,
so
I can't accept that.
But that is what you've been asked.
CFTF people could be that naive, if not stupid.
That's what
they come to Guyana, they talk to people, they read the newspapers, they listen to the television. They don't know the issues of money laundering that take place in this country on a daily basis.
I think that what has
happened...
Are they
that naive?
Between the government and some of the defenders of the government, outside of Guyana, they have been persuaded that this government labors under all sorts of problems. The legal system, where lawyers and judges are not enforcing what is there because it's not tight enough, and
you mean like the constitutional provisions that the government refuses to bring about?
And the opposition, which is blocking the government's efforts. So the CFATF is saying, we'll pass the legislation. Once the legislation is in place, we're going to deal with the rest of it. But you know, the point is this, to the ordinary Guyanese, there's something wrong with a system that doesn't recognize that if you have laws that are not enforced, it brings the legal system into disrepute.
Absolutely.
And therefore, you should not be seeking to put more legislation in place before you prosecute. What CFATF says is that, look, we recognize that enforcement is an aspect. Let's deal with the legislation first, then we're going to come to enforcement. So in truth, let me tell you this, Chris. If the government's bilateral friends abroad don't bring pressure on CFATF, CFATF will eventually get to the point where they have to recognize that the government still is not implementing what is on the cards. And the action that the private sector is having all this angst over is going to follow. If I'm saying to you, if
I don't even know that some people in the private sector have read the legislation. Look, I heard some of the most stupid statements from the leaders of the private sector on that Amila Falls.
Yes.
They had to be completely dumb to say some of the things that. So I would not pay a lot of attention to them. Let me tell you what I did during the recess. I appealed to a minister. I said, look, there's a woman in Trinidad and Tobago with their money laundering, anti-money laundering unit, very competent, experienced in working with a country that had been blacklisted or grey listed, and who had the experience of taking the country from that state to back to approved status. I said, call your colleagues in Trinidad, ask for that person to be seconded, come in here, and whilst the parliamentarians are on recess, get some of the technical issues, apart from the legal issues, done. I don't think those things have been done.
2 points, Chris. The capacity of the Financial Intelligence Unit is affected by two things. One is that it is appointed. The appointment is done by the Minister of Finance, the firing is done by the President, so it's a political appointment. The qualifications that are set out in the legislation, I think between Articles 8 and 9 of the legislation, do not specify, in my view, any qualifications that are actually germane and relevant to the functions that have to be carried out. They are general administrative requirements, which means that you may place someone there with no relevant experience, no formal training in any of the areas, and therefore subject to...
Yeah, but Mr. Greenidge, listen. Sometimes we in the private sector, we employ someone without a formal terms of reference. But you make sure that you interview the person, you look at the person's CV, and you look at the legislation and the objects of the legislation, and you determine what expertise, experience, and qualification that person must possess.
But sometimes you appoint them fully intending that they prosecute nothing. In other words, you give them a sinecure. And that, I think, if you look at the way that the legislation...
So it doesn't matter whether it's the president or the finance, and what the law said anyway?
No, it doesn't. Only that these are the people appointing and dismissing, and therefore the persons appointed are answerable and recognize themselves as being answerable only to them. They're their creatures.
Your friends in the private sector, they actually brought a petition to the National Assembly. I think you've got a petition from the University of Guyana. I hope they will take some kind of order of priority. I really do hope so.
Well, now, you know, Chris, just quickly, petitions are an old right of citizens within the old British system. And I remember Daly and a whole set of others in the old days bringing these petitions to the governor at a time when they believed that the governor was unaware of their plight. we are prepared to examine the petitions. We only hope that when the time comes and other equally important issues are threatening our welfare, livelihood, civil rights, and so forth, that the private sector will be as quick and as diligent in putting together petitions.
Well, I'm hoping that the National Assembly will at least prioritize as well.
Yes, no, I heard you, and I am sure that we will do.
There's another big issue. Whilst the National Assembly was in recess, what I consider to be hostile action taken by Venezuela against Guyana. I haven't heard very much. Yes, the leader of the opposition, Mr. Granger, himself a military man, an ex-military man. But why isn't that being brought up as an urgent, a matter of urgent national business?
The leader of the opposition is in a situation in which you have a president and a cabinet that believes that they are both the font of all wisdom and they are also empowered by the state, by the electorate to act without reference. So, in fact, it was Mr. Granger who called upon the president for consultation. President, all they want, the government, is when we say and do A, you follow. You just simply endorse. Don't bother to expect us to consult with you before you make the announcement. So Mr. Granger asked for those consultations. But let me say, and this is not my portfolio, but I have in the past had the privilege of being involved in looking at some border issues.
No, but I'm asking why isn't Parliament, why isn't the National Assembly bringing this matter up?
I'm coming to that. I was going to say to you that the problem before us is whilst it is the creation of the government, it's the creation of the government of Venezuela, the failure to trigger an outcry and orchestrate an outcry against Venezuela domestically and internationally shows the weakness of our political system. We have asked that this matter be put on the order paper so that...
So you have asked that?
Yes, yes. Whether it will is another matter. It practically depends upon the speaker.
Well, is it as well the fact that we have locked ourselves in for rice and for petroleum products with Venezuela, and we are constrained by those circumstances?
Chris, countries which are at war find it necessary, in many instances, even up to the outbreak of hostilities, to have bilateral economic relations, trade and or various forms of commerce. So the fact that you have an economic cooperation agreement of some sort with Venezuela cannot, ought not, and should never undermine your or be treated as restricting your ability to have Venezuela respect your sovereignty. The fact that
but if someone can pull the plug on two of your most important sectors, well, is it not
well, you should
an
not
economic and diplomatic risk?
It is a risk, but you should not sign an agreement not being aware that that is a risk and not being in a position to have alternative means. All do it. I mean, at the time, even during the Cold War, you had trade between the US and Russia. The point here has, in my view...
This is a little bit more serious, I would say, though.
No, the point...
where your territory is being claimed
yes.
by the other country.
Well, I think the difficulty here is not the trade. The difficulty here is not the trade. The difficulty has to do with the incompetence of the administration. In other words, Venezuela has taken this action against you. First, there were a whole series of steps that we needed to take immediately when Venezuela took such action in terms of the international community and in the various fora of which we are members, including OAS. That's one part, and CARICOM and the UN. The second issue is this. When you have arranged to meet with Venezuela, since it is military action on the one hand, and since it is very clear that the Venezuelan administration finds itself unable to properly control its military as regards dealings with Guyana, you should have had a properly constituted team to meet with the other side. I looked at the team and I was appalled. I was appalled. I could not imagine. Even the
It's
people
almost
that we
comical.
have...
It's almost
That's
comical.
correct. You have, on our side, you have no military people. Normally, when you're dealing with a sensitive matter such as Venezuela, you will have on that team lawyers. Apart from the fact that the lawyers ought to be reasonably competent on geographic matters, you would have a geographer of some sort, somebody who's an expert in terms of the maps and the reading of the maps and so forth. You would also have a legal expert, so that the implications of taking a decision that says, for example, okay, we will put the matter on hold, we will discuss what to do in the future, the legal expert, I'm sure, would be saying to them, you need to look at the implications of that step, because you cannot reward Venezuela for a military and illegal action, an international legal action. Venezuela has now been rewarded by you suspending, or apparently agreeing to suspend activities in the area.
You know,
so if Venezuela were to extend its claim tomorrow to the entire territory of Guyana, our government would have gone by virtue of this agreement and agreed that nothing would happen within the borders of Guyana until such time as they have settled an agreement with Guyana. It is a reflection of utter and absolute incompetence. It reflects Mrs. Jagan going to Venezuela with Hugo Chavez and signing an agreement concerning the exploitation of...
But I want to get on. I don't want to get too deeply into this.
But just to
I just wanted to know if it was going to be brought up at the level of the National
We will
Senate.
try.
Now, the issue of the budget and these local government bills are in fact directly tied into the budget, and the budget process began on July 1.
Yes.
Are we heading for another dysfunction?
You are. The two parties, or let me say that the three parties agreed, I think sometime around June the 18th, the date doesn't matter, but sometime before the recess, that Ashley Singh and myself would exchange letters. And those letters would capture how each of us, having consulted with our side, sees the process of...
But the point I'm making is, the link I'm making, one of the bills, and this is for the...
local
to
government.
meet the constitutional mandate, that allocation of resources.
Yes. Yeah, I know that's where you're going.
Now, so we're not going to have that.
No, you have had you've had no discussion on it whatsoever. I have sent a letter to Dr. Ashley Singh. Dr. Ashley Singh, after receiving 14 or so days after receiving the letter, replies to me saying, let's meet tomorrow. By which time we couldn't even get hold of Kemraj to convene a meeting. And we then suggested that that time would be convenient. Tell us when next would be convenient. We haven't heard from him again.
So we possibly are heading, we'll
Definitely,
have...
not possibly.
The same story with the budget cut.
And the government likes it that way, because they then go ahead to carry out actions that are illegal, in the hope that some point down the line, the minister and his colleagues will be absolved on grounds that it was an emergency or something like this. That's the plan.
I don't like putting you on the spot, Mr. Greenidge, but
you say this all the time.
You say the government is doing these illegal acts, yet it's the government that is bringing action in the courts against the opposition and not vice versa. Why?
The opposition, well, I'm not, first of all, in control of the legal side, but the opposition is aware that they must take action, including, for example, against the president, do gives you an excuse that is completely stupid as regards the constitutionality of bills, and other legislation. We intend to take those through the courts, and in the event that we get the sort of unpredictable decisions that you made reference to, have resort to the Caribbean Court of Justice.
And the Caribbean Court of Justice has really been flexing its muscles
Yes.
recently.
Yes, we have no reason to doubt that they will give proper and unbiased decisions, and expeditiously.
Well, earlier today I was reading a couple of the cases from Belize, and I think, I'm glad that Guyana, I'm proud of Guyana, having taken the lead and say, look, we will go with the Caribbean Court of Justice. We were one of the first two countries,
Yes.
Barbados, because that, I think what we're seeing now, these judges are saying, look, if the politicians are going to be messing around with the revised Treaty of Chaguaramas, we will make sure, and the CSME, we will make sure that is observed.
Well, the point you're making here is that the protectors of our rights as enshrined in the international treaty, Chaguaramas, just as enshrined in relation to the Constitution, is not a certain Mr. Nandlal, but in fact the courts. And that is one of the reasons why the government itself seeks to ensure that the courts remain hobbled.
I think Mr. Nandlal has been corrected on that issue, and I don't think he's going to say it again.
I wouldn't put it past Mr. Nandlal. He is a very enthusiastic lawyer. Let me put it that way.
The bill we're talking about. Has there been any change in position? Because all we're seeing, all this lobbying efforts by the international community, the private sector. Is the opposition, and I'm not going to prejudice the answer by loading it, going to support the amendments as they are to an act as it is?
On Thursday coming, it is to me, if the bill and if the report of the Select Committee is submitted, our reaction is not going to be favorable at all, because that is not.
Who's the architect of that report? Who writes the report?
The report was written by the PPP members.
And it's not been circulated to the wider membership?
Well, let me explain for the benefit of the public what has occurred. We had, the dates now are starting to fade, but let us say we had a meeting on the 18th of October. That is the committee. Okay, the entire committee met, well, except it didn't have an AFC representative.
Yeah.
They met, and in the minutes of the meeting is a record saying, look, in view of the fact that some members and the majority are calling for the opportunity for some people to give evidence orally, and for the additional evidence to come in which hasn't yet arrived, we need 2 or 3 more meetings. The record says that.
No, my question is,
Chris,
who writes the report?
It's important. We fixed a meeting, and the date of that meeting was used by Mr. Granger and Mr. Ramatar for the meeting on the border, which was regarded as urgent. And the expectation was that on the Wednesday following there would be a meeting. Whilst the 2 presidents were meeting, on the day subsequent to the meeting of the president and the leader of the opposition,
2 presidents.
well, you can treat them as presidents of parties. Miss Teixeira arranged a meeting, knowing full well that the APNU was having its shadow cabinet meeting, and then, notwithstanding that there was a decision that 2 or 3 more meetings would be held, concluded the whole exercise, and sending a report.
No,
the report was prepared by that body.
No,
in the absence of other members.
So doesn't the report have to get the signatures of its members?
Oh, no. The report is not signed by the members. The report is transmitted and signed only by the chairman of the Select Committee.
And who's the chairperson of the Select?
The chairperson is Gil Teixeira. And that is where it stands. So as far as I'm concerned, there are procedural irregularities here, and I, for a start, would recommend to the APNU not to even consider that bill next Thursday, because the report of the subcommittee upon which the decision on the bill is to be based is not properly before the House. It's not properly before the House.
We hear all kinds of Armageddon consequences.
Yes.
money coming in, to what extent is that affected? Because the country from which it's coming is not a money laundering,
Yes.
blacklisted country.
Chris, I went into a bank just quickly, I went into a bank last week, Tuesday, let us say, and the clerk told me, this check that you've brought here to be cashed needs to be signed twice. I said it's signed twice. It is to be cashed, and it's signed on the front. If you look on the back, there's a counter signature by the owner of the account. The young lady says to me, no, I mean twice on the back. So as soon as I heard that, a check now needs 3 signatures, 2 on the back by the same person in order to be cashed. I had no more exchange with her. I said, look, call the manager, please.
Yeah.
Okay? But when we have got to that ridiculous point, it's not even as though they're asking the person. You see, the banks themselves are, in my view, abusing the situation that is before us. The truth is that some of the banks are taking precipitate action, some of it far beyond what the legislation itself would require. If you don't satisfy the requirements in time, you're going to run into difficulties. Clearly.
But is it as bad for incoming transactions as it is for outgoing transactions?
I don't believe that it will make much difference. You can find problems in incoming transactions because one of the things you know happens is that they say to people trying to send money into Guyana or Trinidad at the time when Trinidad was having a problem, you know, you can't send $200 at a time, or you can't send 1,000. You have to break it up, down into 20 pieces. A whole set of things like this can actually befall us. And therefore, we need to ensure that we do what is required by the deadline. The deadline, as I started off saying, is not only a deadline about money laundering proper, it's a deadline that the president faces in respect of legislation which is supportive of this bill.
And on the budget, because this might be the final question. If we don't get the local government bills dealing with the one dealing with financing of regions, and if we don't get the consultation as is required by Article 13 and 149C, what is going to be the opposition's, the APNU's position?
Well, I think I would have a lot of difficulty persuading my colleagues to consider the budget anyway in those circumstances. There are already issues pertaining to the constitutionality of the budget as presented in the past. We made it clear last year that the budget as presented was unconstitutional. The Speaker, when forced to give a pronouncement, agreed as regards the constitutional offices.
All right, let me try to get in another question. We've just heard that we're likely to lose a substantial sum of the LCDS money.
Yes.
The Amila, we don't know what has happened with that.
Yeah.
The Marriott Hotel. What is the APNU going to do about all of these extra budgetary transactions running into sometimes much more money than the national budget?
Yeah, sure. In terms of the capital projects, the main capital projects, by and large, exceed the value of the key capital projects that are captured in the budget, the so-called transformative and largely corrupt transactions associated with these biggest of the projects. We will be trying, by means of what is available to us, we've already had resolutions which, as far as I'm concerned, carry the force of law, which require the Minister of Finance and other ministers to do certain things. And we note that nothing has been done on that front. We are going to be pursuing that in this session.
And just in the National Assembly?
Well, it is. I'm not in a position to say what is to happen outside. Oh, no, you mean in terms of the courts as well? Yes, sure.
Because they raise serious constitutional and legal issues.
Yes.
The Fiscal Management and Accountability Act, the Constitution itself. How then, against this background, how do you see 2014? Our economy.
I see 2014.
And given with gold, the uncertain gold and Venezuela, petrol.
You have a budget that is cast on a number of assumptions. It has been cast in the past on a number of assumptions. It will continue to be cast on the same assumptions in the year ahead. And those assumptions are proving to be something like a house built on sand. So there is that dimension, which means that ministers should be looking more carefully at those assumptions. But we as regards these projects, will require that the government be more responsible in putting. You see, some of the projects could
Well,
probably have.
Should it be is more responsible to polite language, because surely it has to be brought into the National Assembly. What
Yes,
does
yes, yes, no
2117 says you can't spend
Yeah,
money
no.
without an appropriation bill of the National Assembly.
The resolution, I think number 19 and 18, or 15 and 16 of 2012 required the Minister of Finance, to withdraw the powers given to those bodies, MISIL in particular, which has those bodies which have not reported on the monies that they've received, have adhered to the rules as regards the use of funds. And these are the bodies that you're referring to. So there's already a resolution in there. We are intending to follow that up.
Mr. Carl Greenidge, I want to thank you very much for being on Plain Talk this evening. It's a special program for me. And for being a friend of the program for over many years.
Thank you very much, Chris.
You know, and I would say this publicly, and it's not meant to embarrass you, we weren't that friendly when you were the Minister of Finance, if you will recall.
Well,
that's how life is.
That is how life is, and these things are not so much at the personal level, but they have to do with how institutions work. But I am happy to have been able to join you this evening, Chris, and to exchange a few words with you for the benefit of your audience. I wish you good luck in the future, and as I mentioned earlier, I would look forward to the opportunity to continue the dialogue under perhaps another name.
Very well. Thank you again.
Thank you and good luck.